is an appeal in the matter of Higgs and Farmor School and another.
My lords, my lady, I appear in this matter for the appellant. Mr. Jones, King's Counsel, and Mr. Milsom appear for respondent. And I wonder, my lord, whether you want me to go read the list.
I think probably not. Well, it wouldn't take very long with the people who are going to address us, but if you went through all the written submissions. Anyway, I think we can take that as read.
My lord, yes. My lord, the other preliminary matter to mention is that we don't, despite considerable effort, because I think we've been distracted, have an agreed timetable for the division of the available submissions.
Well, I was going to raise that. Well, we better impose one then, hadn't we?
Or, my lord, you could accede to the one that I'm about to propose, this.
Let's see.
What we all are agreed on is that I shall be speaking for the most of the morning and a bit of the afternoon.
Yeah.
Mr. Jones will be speaking for the rest of the afternoon. The difficulty is fitting in the next day all the interveners.
Well, is that because we only have a 1.5 day estimate?
No, I understand that the estimate was extended by the court administration to 2 days. But
well, I thought that too, but then what's the problem about the next day? We've only got, if Mr. Jones goes for the rest of today and doesn't go much into tomorrow, we've only got 2 interveners who've got the right to address the court.
That's right.
With 3/4 of an hour each, so that's 1.5 hours.
Right.
And then a reply. So where's the problem?
The problem is...
Well, and perhaps I've just spelled this out. Having the interveners at the end means that although you will have a chance to deal with any points they've raised, Mr. Jones won't. So Mr. Jones may have to have his own right of reply, or whatever you call it, to new points raised by the interveners. So that may mean replies are a bit longer, but even so, am I missing something?
You've added something which will help us a lot, which is a view on the effect of the interveners. And you're having expressed that view, I am very confident that having spoken at lunchtime, we'll be able to hand you the...
Well, hang on, what was the misunderstanding? You thought all the interveners had a right to speak?
No, it was thought that the interveners would go after the respondent. Only some parties thought that. Mr. Milsom did not, it's fair to say. But there was a bit of a disagreement about that, I think it's fair to say.
Oh, I see. Yes, I see. So, no, well, we had already spoken outside.
Right.
It seemed to us we ought to hear the parties first.
Yep.
Sometimes when an intervener is clearly supporting one party, it's convenient to have them after that party. Yep. But I think it makes more sense here to have the interveners after both parties. Yep. And then the only possible prejudice is that Mr. Jones wouldn't have the chance to deal with anything that he wanted to, but that can be built in. So, are we subject to anything that Mr. Jones or Ms. Clement or Mr. Fraser Butlin may say? You'll go a large chunk of today. Into the afternoon anyway. Mr. Jones will respond, and then we got the whole of the rest of the day for the rest. That's fine, isn't it?
Well, that's fine.
Any objection? No. Right.
Okay. Good. Let me go. My lords, I propose to structure my submissions to you today.
Can I just deal with one other thing? We had an email from Mr. Stroiloff objecting to Ms. Clement's speaking note, if that's what it is, saying it's really a supplementary certain argument. I think in a case like this, I can't believe that any of the parties are going to have difficulty dealing with the case as she develops it orally. We now know how she's going to develop it orally, and we're not very sympathetic to cutting anyone out. It's an important case.
My lord, the key fact, of course, is that Mr. Cross has been ill, and that's set back the...
Well, that's another reason. But unless you're persisting in the objection, we're just saying we're not sympathetic to it. Okay.
My lords, I propose to structure my submissions in a particular way. I should say, my lord, that I'm using the phrase "my lord" every time. That's no disrespect. I mean, Lady Justice Falk. It's just rather cumbersome to "my lord," "my lady" every time.
Some people manage, Mr. O'Dare, unless Lady Justice Falk dispenses with it.
I'm prepared to dispense with it if you find it easy.
And of course, there was no disrespect intended.
I'm sure there wasn't, but
thought of the issue.
okay.
Right. So I post-structure my submissions in 6 sections. I want to begin with an introduction to the legal background. I then follow up in section 2 with an introduction to the factual background, especially as insofar as it may not have been obvious to you from your reading. Section 3, I give a summary of the proceedings so far and dive at that point into a clear, I hope, delineation of the precise issues before the court, as to which the court may have been in a little bit of doubt given some of the submissions. And then in sections 4, 5 and 6, I deal with the substantive grounds of appeal, taking ground 1 and 2 together.
Okay, that's fine. I'm afraid you went too fast, but I'm not complaining for me to note all those down. Will you, however, say when you move from section to section?
I will. I'm sorry,
Okay.
I shall speak slower.
No, don't worry. But so, section 1.
Section 1, the legal background.
Yeah.
Some may think it obvious, but it is worth in my submission saying in this case that English law has for many years very warmly and strongly embraced the freedom of speech and freedom of religious speech as set out in other places in the European Convention on Human Rights. Notwithstanding, and that has been fully recognised, that that causes discomfort and indeed anger to some of the listeners. In short, English law has been willing to pay a heavy price for freedom of speech. And that historic preference, if I may put it that way, is set out right at the start of paragraph 1 of my skeleton, where I set out a passage in the judgment of Lord Justice Hoffman from the Queen against Central Independent Television, where he said, in this 3.5 lines up from the bottom, freedom means the right to publish things which government and judges, however well motivated, think should not be published. It means the right to say things right-thinking people regard as dangerous or irresponsible. This freedom is subject only to clearly defined exceptions laid down by statute and common law. It's our case that notwithstanding that strong tradition, one can look at the judgments of the Employment Tribunal and the Employment Appeals Tribunal in this case and wonder whether our commitment is waning. Because essentially, it's obvious that the respondents argued that they were justified in interfering with what was clearly political speech on the rather sketchy grounds that reasonable third parties might otherwise think she was homophobic. It's our submission also, in this case, that this drawing back from the commitment can be seen also in the submissions of the Archbishop's Council, which argues, or so it seems, that those who speak must be extremely careful to avoid upsetting anyone. That's the effect, we say, of the Archbishop's Council's submissions. Fortunately, the tide has not been flowing all one way. And I would draw your attention also to the judgment of this court in the case of Miller and College of Policing. That judgment is not in error, referred to directly in my skeleton argument. And so I would refer you to the text of the case, if I may. It's in volume 8. Page 12 of the bundle, that's where the judgment of the Court of Appeal starts. And the relevant paragraph is paragraph 68 in the judgment of the President of this court. You'll find that on page 30.
Not actually the President of this court, but the President of the Queen's Bench Division. Yeah.
I do beg your pardon.
That doesn't matter. Yeah.
She says this, the concept of a chilling effect.
Well, it's a long. It's probably easier if we read it to ourselves, unless it's a very short passage.
Yes, I beg your
How much of this would you like us to read?
I'd just like you to read the paragraph, if I may.
Oh, I see. Okay. Yes.
And there are at least two things to note about that. The first is a statement that concerns about the chilling of journalistic speech, historic concerns, are now important also when considering the rights of private citizens to express their views. And we shall see later how important that equation is, because ECHR case law, which, as I say, I shall come back to, provides very, very striking protections indeed for freedom of speech. And they can't be distinguished on the grounds, oh, they're journalists. And we go, the court refers at the bottom of the page, the bottom half, to a very well-known expression of the commitment to freedom of speech in the case of Handyside as long ago as 1976. So the court is there very recently affirming the historic willingness to pay a price in terms of offence and such matters in order to protect freedom of speech, because otherwise there may well be a chilling effect on important debates. It might be said that, well, there's no problem because recently this court has affirmed the matter in Miller. But nevertheless, it's my submission that there is no grounds for complacency. This is an age in which there are being advanced on a regular basis, for example, in universities, claims to restrict freedom of speech on new ground, the ground that, for example, some individuals feel unsafe or that they are vulnerable, with no evidence being cited for that vulnerability. And so I draw to the end of this section by saying this. The appellant has appealed an order in its favour by Justice Eadie because, or an order that remitted the matter to the Employment Tribunal with a direction to reconsider. The appeal is brought on the basis that that is, given the tradition of freedom of speech, an astounding thing to say, and contains an astounding proposition that in the context of this case it could be It could be that this speech, this political
What's this
speech,
astounding proposition? I haven't heard what the astounding proposition is.
the outstanding, well, it's one I'll develop later.
Okay, well then, fine.
And one of the things which will help me to advance it later is my second section, which is the factual background, particularly as far as you would not have necessarily noted it in your background, in your reading. The first point to note is this, that the appellant had worked in the school since 2012, some 7 or so years, working amongst children who were LGBTQ, amongst others. And there had during that time been no complaints about her work. And indeed no evidence either that her views had changed during that time. She was not someone who only recently come to have the views she supported in the posts. The second factual point is this. The appellant had children in a primary school, children of her own. And that is referenced in paragraphs 4 and 11 of the EAT bundle. And that
So the EAT bundle.
EAT judgment, I'm
Yeah.
sorry. And that in itself is found at page 50 of the core bundle.
Yes, no, don't worry about the references for that. We've obviously got that.
In essence, in asking other parents to read this, others to read this material, she was in part addressing fellow parents. She could not, on a remission back, possibly have been portrayed as solely as a zealot. Indeed, it could be argued, and will be argued if it's remitted back, that she was in effect exercising her ECHR rights under the second protocol. First
Well,
protocol.
just you keep saying if it's remitted back. Have I got this right? Your primary submission is it shouldn't be remitted back. That can only be on the basis that once we've identified the correct test in law and applied it to the facts, there is only one possible outcome. And that is your primary submission.
It is.
So submissions about the facts are not only relevant to if it's remitted back, they're also relevant to a decision that you're asking us to make.
Oh, absolutely so. I'm
Yeah,
sorry.
sorry. No, I'm not picking you up. I just want to make sure we answer any cross purposes. Yep.
No, absolutely. So the next matter, which you will have to consider, as you just indicated, is that the appellant sent forward messages she had received from the United States. There are a lot of references in this case to the appellant's posts, but that is capable of misleading because these were not posts she had written out for herself. They were things she'd received from a board.
Can we be clear about that? The first one, which generated the complaint, I know it's the first in time, but the one that generated the initial complaint was a cut and paste. It wasn't a mere forwarding. It was her own post, but it involved a cutting and pasting of something she had received.
Indeed.
That one I hadn't picked up. If you tell me it's so be it. Was from America. It was the later one, which was a direct forwarding of an American post. Have I understood that correctly?
That's absolutely right. And
the first one is, though it's a rather general term, you can work out exactly what it's referring to, appears to be about what is said to be the policy of the English or the UK government.
yes.
Yeah, okay. Thank you.
But in both cases, whether cutting and pasting or forwarding, the text had been formulated initially by someone else.
Yes, I see that, but that's obvious. How is that material?
It makes
clearly, by forwarding something, you're normally endorsing it.
Yes, but in free speech terms, it raises this question. Supposing she had agreed with the message, but recognised that some of the language was strident, what was she to do? Was she to not post it at all? Or was she to essentially rewrite, reformulate the contents of the post?
Well, it might be said that's a matter for her. If she agrees with the subject matter but doesn't like the way it's expressed, since the way it's expressed is intemperate, she can indeed express the same opinion in more temperate language. Nobody's asking her she had to re-forward it. Or she could, it sounds a bit unrealistic, but I mean, just testing it out, she could say, well, you may not agree with exactly the way this is put, but the underlying message is very important. You could have said that.
Indeed, and but my lord used the language of how realistic is that. My submission is simply that it is in itself a fetter on freedom of speech. If those who receive material in documentary form, which happens all the time on the internet, have to scan it for unhelpful terminology before sending it forward. In my submission, that is simply not realistic, a realistic requirement of fairly straightforward and normal people such as Mrs. Higgs, or indeed anybody. Imagine, I would say.
Can you just help on the facts? If you turn to page 149 behind tab 12.
149 behind tab 12 of the
core bundle. Facebook post beginning in capitals. Please read this. They are brainwashing our children.
Yeah.
And then on November 7th and so on. Are the opening words in capitals Mrs. Higgs' words, or are they cut and pasted from someone else?
The reference to brainwashing,
Yes.
and I apologise for not separating the paste word by word, as it were, was her language. The other matters weren't.
From on November 7th onwards, that's the cut and paste.
Yeah.
I'd understood the fact to be slightly different from that, only in that her own words at the very bottom, please sign this petition, they have already started, and then not quite sure where it goes on. That was added by her as well. So it's the bit in between, from on November 7th down to public arena, is somebody else's post which she has cut and paste.
Yeah.
Yeah.
Yes.
Good, thank you.
But I would, before moving on from these, I'd just like to reiterate my submission, which is if there was to be applied across the board a requirement that those who wish to distribute materials they've come across on the internet have to vet them for intemperate language, that would be a significant fetter on freedom of speech. Should I go now to, insofar as we've not dealt with it already, the posts themselves, which are found on page 47 of the core bundle.
Well, that's to say,
The
EAT.
That's absolutely right. But there are other issues which I wish to draw your attention as well, because there are conveniently set out in that posts a number, on those pages, a number of other matters. Looking at the end of 5, you can see that not only am I submitting at the end of paragraph 5 that she was exercising the right of parents to have children educated in line with their religious beliefs, but she was too. And this is not something that's been dreamt up, as it were, in chambers. Paragraph 6, you have the first complaint, and you see at the end of, you'll have read it, you see at the end of the post, the second half, beginning, and this individual may exert influence over the vulnerable pupils that may end up in ISIS for whatever reason. I find these views offensive, and I'm sure that when you will look into it, you will understand my concerns. The two things that I draw your attention to are firstly, the complainant was complaining about the views of the appellant. Though the school later made great play of the language, the complainant was, we would say, much more straightforward. She didn't agree with her views.
Yeah, but we're not concerned with the complainant's actions, we're concerned with the school's actions.
Yes, but I'm going to argue later that the school adopted the views of the claimant.
Okay.
And in order to do that, I have to establish what those views are.
Yeah, I see.
And the concern is that the individual may exercise influence over vulnerable pupils. The first thing to say, the important thing to say about that is that there was no basis, as far as we know, on which the complainant could formulate that concern other than the views she had read.
Well, we haven't got great detail, or if we have, I haven't found them, about exactly what the claimant's role was in the school where she worked. But it was working with vulnerable, with pupils who've been disciplined in some way or put into yeah. I can't remember what the terminology is, been cordoned off. she had a pastoral role with them. So to that extent, there was a factual basis for what is said here. You're going to say, yes, but there is no evidence whatever that she actually used that position to express those views.
Yes.
That, of course, I can see, yeah.
But it goes further than that in this sense, that as I shall develop my submissions further later, the complainant was effectively stereotyping the appellant. Because she has these views, we should be afraid that she will do this.
Yes, well, that's a part of your submissions that I've had some difficulty with seeing the relevance of, but you're going to come to them later, so...
Paragraph 7. We see the other post, and we see there, again, the direct, even more direct, setting out, on this occasion, of the complainant's own liberal views as opposed to the appellant's views. Same point, but further evidence for the same. It's also important to consider, and this ties in with the point made earlier about the appellant being a parent, to note what the appellant's motivations were in sending forward these posts. And I set that out, set out a relevant instantiation of it in paragraph 15 of my submissions.
Just give us the page number in the bundle. So,
Sorry, I've got.
oh, don't worry, we can get there pretty quickly.
196.
Must be 196. Thank my lady's quicker than me. Yep.
The investigation report, referenced there to the supplementary bundle where you'll find the actual document, sets out the appellant's explanation for what she was doing. She's not critical of the school, they're following government policy. She repeated that it's about the government, she repeated about government policy, highlights as this happening in her son's primary school, and people need to be aware of the books they're reading and then make their own judgment. It was never in dispute that these were motives of this kind, were the appellant's motives, and indeed she was criticised later in the dismissal letter for holding fast to them. But what this paragraph illustrates very carefully, very clearly, is that this was a very strong and clear example of political speech. The appellant wanted other people to be aware of what was going on, to do some reading, and then to make up their own judgment, to make their own minds up. In my submission, it's precisely and very clearly that sort of transmission of information which is of crucial importance to the thriving of democracy and which very clearly underlies Article 10 and Article 10 when, as in this case, it overlaps with Article 9. So,
is it right that she was a parent as well as
yeah, oh yes.
a parent of a boy at school?
No, she's a parent of a boy in another school.
Yes.
Right.
The respondent school is a secondary school, and she was a parent of a child that's obviously at a different primary school.
I think that's right, I'm just checking. Well, I'm instructed that in fact there were two children, surprisingly. One was in the other school, the primary school. The other one was in this school.
Oh, I see. That I hadn't picked up. But her posts were about what was happening to children in primary school. We can.
Yeah.
Well,
That's what
if I'm wrong about that, that's. But the text certainly of the original one, the one that generated the complaint, is about primary schools. Am I? Isn't that right? Starts.
Yes.
On November 7th, the government consultation into making relationships education mandatory in primary schools. Oh, I see, and relationships and sex education mandatory in secondary schools. Closed. Yes, I see.
So it was a.
No, it's just as well I picked that up. Yes, well, I'm not at the moment convinced how central any of this is, but insofar as the concerns expressed in the post that she sent were about relationship and sex education in secondary schools, that would, in the case of her own children, affect one child in a different primary school and one child in the school where she was in fact teaching or employed.
Yes.
Yeah.
And of course, the motivation is not just personal in that sense, but it's also political in the sense that the matter was up for debate at that time in Parliament.
Yes, but I just think the second fact that you sought to emphasise, you said, as I noted it down, I may not have noted it down entirely accurately, the appellant had children of her own in a primary school. And that's not quite right. She had a child of her own in a primary school.
Yeah. I beg your pardon.
Right. So you're going through emphasising points on the facts.
Yeah.
Where are we going next?
We are going now to page 101 of the core bundle at para 50, and you don't need to unless you want to, unless you turn to it, unless you really feel you need to, because the point is a very simple one. In that paragraph, the tribunal finds that the post was read by as many as 100 parents.
Parents at which school?
They don't say.
Well, perhaps we better just look at it, see what the context is.
Parents of children at the school where she
Oh, I
worked.
beg your pardon. Sorry.
So the secondary school. Well, 50. It doesn't say how many parents.
No. With respect, Mr. O'Dare, you've not
Oh,
correctly represented what the paragraph says.
Yeah. So I do beg your pardon. I misread that. There were over 100 people who heard it, and they included parents at the school where she worked.
Well, she had basically what it means is she had over 100 Facebook friends, and her privacy settings were friends only.
Yeah, and that included.
And that included parents, but that could be anything from 2 to
Indeed.
could be any number. Yeah. Okay. Thank you.
But notwithstanding that, I do say one thing is clear from the text of the judgment. It is that there was only evidence of one parent being offended. There was evidence of other parents not complaining. This was a situation in which only one parent complained. And in my submission, that is very, very important because the burden is on the respondent. I shall come to deal with the legal issues a bit more closely in a minute. The burden is on the respondent to show that there was a justification for infringing her freedom of speech. But there is evidence of only one parent actually complaining. And that, in my submission, is very significant in the balancing exercise. I come now to part 3 of my submissions, which is
what's the headline for that?
Litigation.
Right.
The litigation
Yep.
issued before this court.
Thank you.
Before the Employment Tribunal, both parties submitted and agreed that the issues in the case had to be decided in the light of Articles 9 and 10 of the European Convention. Now, as to
Can
what
we just see the term, you had to be said in the light of the convention?
that was.
That's, I don't know whether that's exactly the language used. It's slightly.
No, it's not. That's a
What was the language used?
Well, I read the appellant's submissions at first instance again last night,
Yes.
and the argument was that the domestic provisions had to be read in the light of the convention.
Sorry, and in fact, if one looks at paragraph 34 of the ET decision at page 98, they say what they understand.
Thank you. That's very helpful. Let's just have a look. Well, hang on. Oh, I see. When it starts, we were bound, that is summarising Mrs. Higgs' submission.
As I understand it.
Sorry?
As I understand it, yes.
Yes, I agree. It looks like that. Because you really got to look up to para 32. Yes, well, thank you. That confirms really what Mr. O'Dare. Well, hang on. Mr. O'Dare, you said that was both parties agreed. It's clear that was your position. And it's not a statement here.
Well, it goes on to say, describe the school's response from 35.
Yes.
Appear to accept the premise. On a quick look.
Yes, I'm not looking at the part. I haven't yet found the part of the tribunal setting out of the submissions which deals with their position of exactly the way in which Articles 9 and 10 are relevant.
My Lord, I don't know if I can assist. I understand that the submissions were supplied to the court as a separate bundle.
They were.
This morning. On page 26.
Well, before we get to those, Ms. Fraser-Buckley, I was hoping to go for those in a minute, but can we just bottom out what the tribunal said the position was? I haven't, just on a quick read, found where the tribunal expresses what it understands the respondent's submissions to have been on the question of the relevance of the convention, how the convention fitted in with the domestic legislation. Doesn't look as though there's anything there, is there? Doesn't matter, but I mean, everything matters, but it's not a point of central importance. I just wanted to bottom it out. Let's look at what the reference Mrs. Fraser-Buckley just gave us.
Page 26 of the...
This is what was supplied overnight in response to my request.
Precisely, and it's paragraph 3.
Page 26. So this is... sorry, mine isn't paged.
It must be tab 3, is the respondent's skeleton argument.
But that's in the EA...
This is the Employment Tribunal skeleton.
Employment. Okay, well, let's just... We didn't have these in any bundle, so mine's just...
Got them in a bundle.
Sorry? Oh, I see. Sorry. You supplied a bundle this morning, did you? It's my fault. I hadn't seen that. Right. So you said page 24.
Page 26,
Page 26.
paragraph 3.
Yes.
And my lord, it may help you to quickly flick to page 30 and paragraph 13 and following of Miss Grenan's submissions, where even without spending a long time on it, you can clearly see that she is setting out an agreement that she has no dissent with the applicability of the...
Yes. Look, don't get me wrong. I'd be amazed if the parties were not proceeding on that basis broadly. I just wanted to see exactly how it's been formulated, because one of the problems that's come out of particularly of the intervenor submissions, is how exactly and the terms of the domestic legislation are to be reconciled with Articles 9 and 10, and whether they can be completely reconciled. And I just wondered to what extent that the paths had been sold on that, so to speak, in the Employment Tribunal. Perhaps unsurprisingly, it looks as though nobody looked at it very deeply. They just used formulas like in the light of, or so far as possible, and just got on with it.
And there was no dissent to the broad...
Yeah,
broad
okay.
expression.
Well, let's not spend any more time on that. I just wanted to see exactly what the material said. Thank you.
I'd like to take you to the core bundle at page 103. Which, and we see there paragraphs, particularly paragraphs 61 and 63, what might be called the nub of the Employment Tribunal's reasoning. And paragraphs 61 and 63 can, I think, fairly be seen as a reformulation of the same overall concern.
Sorry, well, I mean 61 and 63 are saying the same thing.
More or less, yes.
Yes, I see, sorry. Yeah. Same thing as each other. Yeah. Okay.
And the answer that the Employment Tribunal gives was that Mrs. Higgs was not dismissed and subjected to other detriments by reason of her beliefs, but by reason of these other matters, in particular the fact that third parties might...
Yeah, well, sorry, I wanted to... We know all this.
Sorry,
this is why we're here, and the EAT said that was wrong.
Yes. Now, I'm sorry, I didn't wish to delay the court in any way. I apologise.
No, I didn't mean to be tetchy, but
I understand.
You don't need to spend a lot of time on it. Yeah.
What I do want to say about that is this, that this mode of reasoning can fairly be called a separability argument. And the argument goes like this, and it's come up in a lot of cases: you were not dismissed by reason of your belief or speech, but by reason of something else, the manner of your speech, the mode in which you expressed it, and so on.
Well, yes and no. I mean, it's not really like the ordinary separability cases at all, because what's being distinguished is not the speech on the one hand and the manner in which it's expressed on the other, which is a classic separability case, but it's a distinction between what you said and how other people would interpret what you said.
Yes.
So I'm not totally convinced that this is, as it were, a following of the Martin and Devonshire line of cases at all.
Well,
and indeed, clearly the AT didn't think it was.
Well,
it was wrong for a different reason.
Let me just say this then. If one looks forward to paragraph 67, 66 and 67, 66 says this: our only task was to decide if there was a causal connection between the beliefs in paragraph 30
Yes.
and the treatment meted to Mrs. Higgs. We concluded there was not. Our view was that her harassment was not because of the relevant beliefs, and accordingly a claim of direct discrimination failed. So whilst I would agree with you that it's not a classic separability argument, it is a separability argument in this sense, that what it does is assert that the causal connection runs not from the belief or the characteristic and the mind of the discriminator. There's no such causal connection, so the argument goes. The causal connection goes from the mind of the discriminator to something else. And it's a slightly different something else, but it's still something else, and it's still an argument about what's going on in the mind.
It would help me, sorry, I see exactly the same as this, but why are you emphasising all this? We're all agreed that the tribunal got all this wrong for the reasons given by the EAT.
Yep.
And there's no cross appeal. And going over this, at the moment, I don't see how it's going to help us. We've got a lot of rather difficult points to come to, and I'm not quite sure why this isn't just delaying us getting there. I may be wrong, but can you just show me why this matters?
It matters, in my submission, in this sense, in that the argument we have just considered is an example of a category of argument which comes up regularly and which shuts claimants out, rightly or wrongly, from any consideration of whether the objection was reasonable. And I would simply say this, putting it most blunt, that a lot of the submissions put forward by the various other parties to this case seem to me to assert that this claim can be won by showing that what was happening in this case was just a separability argument and a justified one at that.
I see. Well, we'll come to that, but thank you. That's why you're showing us this. Yes, very well.
Right. The next thing that I want to address is before I come to the Court of Appeals decision, sorry, the EAT's decision, is the decision of this court in Page. And my justification for addressing this case, which is binding on this court, as my Lady Eustace Lang has said, is that if you read the documentation in this case, you will quickly perceive there is some degree of debate about what that case provides. And so with that in mind, I will look with you, if I may, at Page.
Yes, is this your section 4, or just for my note, or is it a digression in the course of section 3?
No, this is the litigation. I'm going to look at Page.
Yep, no, that's fine. It's just I'm not going to won't make a separate heading.
Show me.
Yep, thank you.
Bundle 7. So the page is found at page 421. And I want to take you.
So sorry, where do we find Page?
It's in volume 7 at page 421.
Sorry, annoyingly, I I took it out, and I found it now. Thank you. Yep.
So, I want you to begin by taking you to paragraphs 36 and 37. Now, we'll all be very familiar with the facts of page. And I want to begin with you looking at paragraph 36, as I've said. And what I'm going to do in the following brief submissions is set out what I see as the structure of page, from which in my submission its meaning emerges, and in the light of which we need to understand the EAT's judgment in this case. So in paragraph 36, my Lord, you say that you're going to begin by dealing with the matter by looking at Articles 9 and 10 of the Convention, as Mr. Diamond bid you do. And at the end of paragraph 37, you say this: in his skeleton argument, Mr. Diamond submits that in every case of religion or belief, a tribunal should start by deciding where there has been a breach of the claimant's convention rights, which can then inform its analysis under the 2010 Act. I myself do not think there needs to be any such rule. It's ultimately the Act from which the claimant's rights derive, and there can be nothing wrong in a tribunal taking that as its primary analysis. And then this is...
Well, I think it's the primary basis of its analysis. Yes. The context you've got to appreciate is we were taking Mr. Diamond's various challenges, and as I think is apparent, one of Mr. Diamond's complaints was the tribunal should have started with the convention. And we were simply saying there's no general rule.
Yeah, absolutely.
We weren't saying in other words, we were saying they weren't wrong in law to instead start with the Act.
Yeah.
But I don't think we were saying anything more than that.
Well, in subsequent debate, a lot of emphasis has been placed, and you'll tell me if I was wrong, if we're all wrong in doing that, on the last sentence of paragraph A to B on 954. You say there that it's ultimately the Act from which the claimant's rights derive. That's clearly right. And then by way of qualification, but of course, if there's reason to believe that a particular approach or outcome may involve a breach of the convention rights, that question must be fully considered. And in my submission, and it may not directly be relevant, that's right, and it leads to the conclusion that if convention rights have been infringed, the Act must be determined accordingly. You then go on in following paragraphs to set out very fully an analysis of whether Article 9 or 10 was engaged and was breached. And in paragraph 67, long consideration, you set out the answer, which is that there was no breach of convention rights on the facts of this case. And then, in 67 on into 68, you effectively analyse the facts again from the perspective of the Act. and indeed, and you observe again that that is the origin of relevant rights. So in the following paragraph unit 68, and 68 is very much a crucial paragraph in this case, because it was the one that was cited and relied upon by Mrs. Justice Eadie in the EAT in this case as the basis for making the order that she did. And if you haven't already done it while I'm speaking, it may be worth your while just glancing through that paragraph.
Yes. The word which actually puzzles me on rereading is consequences. I wonder whether that should have been circumstances, but maybe not.
Well, I don't resist you that.
We must, of course, construe this objectively. I'm not here to give evidence about exactly what I think.
If it's any
we should read as if it's anybody else's judgment. I mean, I'm not joking. I mean, I think
no. That is not. I mean, if it's of assistance, Judge Taylor in the EAT said to me when we were considering a case of this kind, surely he meant circumstances.
Oh, really? Well, there we are. Perhaps we can blame the law reporter. I suspect not. Yes.
So there we have a very important paragraph, and it seems to me that in that paragraph you set out the separability argument and how it can rescue a defendant who might otherwise be in danger of being held to have acted by way of belief. And it was an argument, as we can see from paragraph 69, that wasn't just dreamt up by counsel before you in Page. It had a significant history in the cases cited below. But the important...
Yes, just to, I mean, I'm not asking to predict. Chundal, in fact, was a decision of mine. And I looked at it again, it's very short, but it does make this distinction. Grace, who is the judge in Grace?
I think it was Mrs. Justice Eadie.
Mrs. Justice Missing, my lord.
I didn't hear.
Justice Missing, my lord.
Mrs. Justice Missing, and then Wasteney was Mrs. Justice Eadie.
So,
she then wasn't. Yeah.
But the key sentence, if one likes, is this: of course, if the consequences, circumstances, are not such as to justify the act complained of, they cannot be seen as separate from objection to the belief itself. That is the...
Well, yes. The thinking there, you skipped over the word sensibly.
Yes? Not deliberate.
Well, I read that more as a factual proposition. That if someone says, I wasn't dismissing you because of what you said, but because of the way in which you said it, and you look at the way in which they said it, and the way in which they said it was perfectly unobjectionable, you're going to reach the factual conclusion that the respondent's account of their reasons doesn't make sense because there was nothing to which they could have taken objection. I think that's that appears to be the thinking there, and the word justifiably, which I know has also caused some difficulty, perhaps has to be read in that sense as well. So I'm repeating myself, but it's an important point. Take a very straightforward case, and not all cases are this straightforward, where someone expresses let's say, a religious view, and is sacked for it, and the employer says, "Oh, I don't mind you being a Christian or a Muslim or whatever it is. I just didn't like the way you expressed this particular Christian doctrine or whatever it might be." If that's simply not credible because there's nothing you could reasonably take objection to, then you make a factual finding that wasn't their reasoning.
Can I say two things in response to that? One is just an observation.
It doesn't read to me like a proposition of law.
Mrs. Justice Eadie did read it in that way.
Well, in that case, maybe she was wrong, but I'm just exploring this with you.
Yeah. Let me put an example that suggests the contrary, based on the facts of this case. You have an employer whose employee gets involved in politics. And in particular, she supports a political movement within Parliament. The employee is dismissed, and the employer says, well, we didn't do it because of your beliefs. We did it because of the way you expressed yourself in various documents. And the employer, where you express yourself in various documents. So the case comes before a tribunal, and the employer says, well, no, it wasn't by reason of the beliefs, it was because of the campaign, it was because of the language. And the evidence is absolutely consistent with that. Contemporary documentation shows that that's what it never occurred to them to think that the political speech was important. Is it right?
So I'm not sure I'm understanding your example. What does the contemporary evidence show that their internal thinking was, we're going to dismiss them because they expressed Labour Party views? Or does the internal evidence show that they clearly dismissed them because they thought this is shocking, offensive expression of Labour Party views?
The early.
I don't know which your example is. I just didn't follow you. Is it the former or the latter?
It's the latter.
The latter, right? I see.
But it's not shocking and offensive. It's just bits and pieces here and there, which are in the language, which are unfortunate. But that is their reason. We do it by reason of the fact that you use this poor language in this political document. If that
to take a very silly theoretical example, but just suppose that throughout it the person used split infinitives, which we were all told at school we shouldn't do. Theoretically, if you could show that this was a person, that this decision taker was a grammar pedant, and was perfectly capable of dismissing someone for wrong punctuation or split infinitives, and that was shown to be the case, you'd have a slam dunk unfair dismissal, But you, I think, thinking aloud here, you wouldn't have a dismissal for on the basis of opinion, because perfectly genuinely that wasn't the reason he'd done it. Separate question, would you believe for a minute that that was their real reason? Well, in a ludicrous example, you might, but in 99 cases out of 100, someone says, I wasn't dismissing you because you're black, but because you don't write English properly, you wouldn't believe them. You'd say, that's your excuse, but it's perfectly obvious you're dismissing them because they're black.
Well,
that comes back to my point about the propositions here being factual rather than legal. But what do you say about that?
what does that mean about being factual, not legal? I am saying that whether or not a alleged separable reason for dismissal rescues the respondent cannot only turn on causal questions. And that is because, amongst other reasons, if you did formulate the law in that way, you would almost inevitably be putting the law in a state which was contrary to the ECHR.
Well, I wonder. If you went to Strasbourg with these completely unrealistic examples, but just bear with them, why would Strasbourg take a different view from the one that I've just
Because Strasbourg
expressed to you?
evaluates, addresses purported restrictions on human rights in qualitative terms. Article 9.2 is not about what was the employer genuinely believing. It is about whether what the employer did in restricting freedom of speech was a proportionate means of achieving legitimate aim, justifiable.
Yeah, no, well, I see exactly what you're saying. I'm not sure this particular distinction has ever had to be considered in Strasbourg. Because these cases of this sort, well, they do sometimes come up, not in the silly examples I put to you just for starchness.
Yeah. I mean, another example which I think causes difficulties for the position you're putting forward is this. Suppose you have an employee who wishes to stand for Parliament or to local council or something like that, and that person has views similar to Mrs. Higgs, and then a number of customers of the employer object. They object to someone to whom they are principal supplier employing someone who has these beliefs and standing for these things. And the employer is able to show in a subsequent ET that they did not want to dismiss the employee, but they were going to do so by reason of the difficulties they would otherwise face with their customers.
Yes.
That, with respect, is a good example, I would say. And it's a good example because both of us perhaps have put rather unrealistic examples forward. But this really matters in my submission.
It does matter, and it's very clear. The law, both in Strasbourg and separately in ordinary British discrimination law, is that that's not an acceptable distinction.
But why, with respect? Because
the reason is still the reason I'm not prejudiced against you, but my customers are, is an inadmissible distinction. The reason is still your race, even though it's your race through expressed through your customers rather than yourself. The causative reason is still your race. That, I think, is the analysis in cases like Dinn and Westminster and whatever the Strasbourg
But you wouldn't get to a causative analysis on the view of the law you're putting forward if the employer could show that my reason was the customer's ire.
Well, I think that's because you're interpreting the view I was putting forward to you for the sake of argument, honestly saying, more widely than it needs to be interpreted. You would you could simply say separability isn't admissible in those circumstances. You could say for policy reasons, but you could actually say because the reason is still your race. In my grammar pedant example, the reason genuinely, though incredibly unreasonably, is the fact that you can't spell.
My lord, I'd say this, that when one is reduced, and I mean to no disrespect in the debate, when one is reduced to saying, oh, but that's an inadmissible reason, that is to, with respect, and found opaque reasoning. There is reasoning underlying why it's admissible, and just calling it inadmissible leaves...
Well, I did try to give some reasons, and I think the intellect, I'm thinking aloud here, as you can tell. I've been doing some thinking about it before. There is an intellect, I use inadmissible as a shorthand. The reason why it's inadmissible is that the underlying cause of the way in which you have been treated is your race. I'm sorry to slip, it doesn't really matter which protected characteristics we're talking about. And that is so whether it is the employer themselves who is prejudiced against people of your race, or whether the employer's customers to whom the employer chooses, to whose views the employer chooses to give priority. So I don't think inadmissible is just a word that escapes analysis.
Could I just suggest, to continue the debate, this further point, that the mode of analysis that you're putting forward very much makes everything, at least on the face of it, turn on causation. Then one comes to inadmissible reasons. The real example, the real merit of applying an objective analysis, as the Court of Appeal, EAT rather, did in this, said the EAT should in this case, is that it's transparent. You consider what was the justification for interfering, was it proportionate mean achieving legitimate aims, so on and so forth, and come to a conclusion which is at least explicable and justifiable in legal system terms and transparent. And in my submission, we don't get there just by calling things inadmissible.
But is what you're saying, and I'm not saying whether this necessarily means it's wrong, but is what you're saying that in fact the page analysis is simply contrary to the convention, because it doesn't apply an objective analysis. But if you're, just to spell it, if that is so, I think you're going behind the ratio of page, aren't you?
Well, of course.
Because page, rightly or wrongly, I'm very happy to have submissions that is wrong, and we have to decide what the real ratio is, as we're bound by it. Rightly or wrongly, believes that the causal analysis, which we all agree is the conventional way of analyzing section 13 and direct discrimination, is reconcilable with Article 9. But I think the logic of what you're suggesting to me is it isn't reconcilable. in which case Page is wrong.
Well, it's fair to say that, as my lord observed earlier, what Page means is, theoretically at least, an objective question on the basis of the text. It's always difficult to make that submission in this context. But what I would say is this, that the best way of understanding Page is that that it is an objective analysis. And I just want to take you to a particular paragraph which will help to demonstrate that. I'll have to come back with the references later, but my submission is this, that in Page, the Court of Appeal, held up the conventional analysis and the Equality Act analysis and went through them both because of the structure of the submissions, and essentially held that the outcome was the same.
Yes.
And that was not a coincidence, because my lord held in a passage that escaped my moment, that it was highly desirable for the two streams of jurisprudence to reach the same result.
You know, I did. I can't find it either, but it's there, and
Yeah.
and it's it was certainly part of my, I can say, because I've agreed with our thinking.
Yeah. But if that's right, it
It's
can't...
74.
So, thank you very much, lady.
Yes.
Now, if that's right, the two streams of jurisprudence, both in that case and generally, lead to the same conclusion. It simply cannot be that there can be no objective consideration when one is looking at the separability.
I'm sure we don't go say there's no object. The whole question of justification is objective.
Oh, okay.
But the first question is, what is the reason for the act complained of?
Yes.
And once you've established that, and that involves a subjective element.
Yeah.
Once you've established that, if if justification is permissible, justification is entirely objective.
Well, I may have misunderstood the term of the debate we were having, but if that's right, if you're with me on that, and read paragraph 68 in that way, then justification is indeed objective, as I say it should be, in order to drive the two streams of jurisprudence down the same track.
Okay, well, we're all going to do it. That's been, to me at least, helpful in clarifying the issues, but there's a lot more to be.
There is.
There
is.
Okay.
I'll continue. I'll come now to a point I might be said that I should have addressed it a while ago, which is the judgment of the EAT. I want to take you now to certain paragraphs of that. It's in the core bundle. And I want to take you to no, it's in the core bundle, isn't it? Sorry. Excuse me, my computer locked me out. I'll come back to that. But or to the text, but my point is simply this, that if one looks at paragraphs 56 and 57 and 81 and 82 in this, it is clear that Mrs. Justice Eady read Page as requiring the consideration in this case of whether the respondent's objection was a proportionate means of achieving a legitimate goal.
Yes.
In essence, she drove down the second of your two lanes of analysis, looking at the matter through the lens of the domestic legislation, but read Page as requiring the respondent to show that what they did was a proportionate means of achieving a legitimate aim if they were to succeed on remission and indeed in front of you. Now, the key point about that case...
Can I just be clear about this? Let us suppose that we were in the High Court, so there was a direct claim under the Convention. Would her direction have been wrong?
No, it wasn't, because she inserted that direction, she inserted what would be the High Court list of issues into as a mode of determining whether
Yeah, I mean, all this points out what would have been obvious anyway. The intellectual problem in this case is whether, and if so how, you can reconcile what we described in Page as the very different approaches of the very different structures of Article 9 on the one hand and of the domestic discrimination legislation on the other, so as to achieve the same result in all cases. And as I understand it, well, what are you saying the reconciliation is, or are you saying there isn't one?
Could I make another point, but coming back to your point, if I may, which may help us in context? It's very important for everybody in this case not to lose sight of the fact that while the appellant has appealed in certain respects from the judgment of Lady Justice Eady, Mrs. Justice Eady, it has not appealed that part of her judgment, which is, I think, found at page 90, paragraph 94 of the judgment,
where she says what the question is on which it might be determined on remittal.
That's not been appealed. Now, the response...
was that because I haven't had a chance to digest the material we were sent overnight? Was that because they tried to, but they weren't given permission? Or because they didn't even try to? As I haven't... Don't worry if you can't. Anyway, the fact is it isn't appealed. Yeah. Okay, where are you going from there?
I'm going there with that, which is that, but at the same time, neither has the respondent obtained leave to appeal.
Oh, we're at cross purposes now. So you mean you haven't appealed the basis?
Yeah.
So sorry. Forgive my last intervention. Yes, I see.
So we haven't appealed.
Yeah.
And the respondents have tried twice to cross appeal and been told they couldn't.
Yes, sorry. Yeah, I'm with you now. My mistake.
And it follows, and this is very important for this hearing, that the only issue before this tribunal is as follows, or at least the issue on this part of the case is as follows, namely whether the respondent's interference with the claimant's section 9 and Article 9 rights, 910 rights, was a proportionate means of achieving a legitimate aim, including within that the consideration of whether the interference was according to law.
Yeah.
That's it. That's where we are.
Yeah.
So, in a sense, the analysis we've been through is, at best, part of the background.
Quite. Well, perhaps I've allowed myself to be too much distracted by the intervention. So,
Yeah. So, just on this point, however, about
but
the
we do want to get the law into the best possible position.
Yeah, I understand that. Just on the EAT decision for a moment, it's also plain from the text of the judgment, in paragraph 94, that Justice Eady did not give permission to any party to lead new evidence.
Well, she said the case should be remitted and it should be decided on the basis of the findings of fact already made.
But that, of course, is, we say, assists, frankly, the claimant. The respondent may say it doesn't, but that's what we say, that things they might wish to have said can't be said because of the terms of the unappealed order. May I proceed, my lord?
Oh, sorry.
Sorry, I thought you were thinking about it.
No, well, I'm always thinking. I was waiting for you to speak.
So, my next section is section 4 of my submissions. It deals with grounds 1 and 2 of the appeal, and which are, really speaking, proportionality and manifestation of speech. I want to begin by showing you why there was no possibility of a meaningful remission here, by taking you to the decision of the ECHR in the case of Vajnai and Hungary, which is found in the 4th volume of documents, and at page 239.
Which volume did you say?
Number 4.
Number 4. Thanks.
Can I take you to paragraph 47, which is on page 240? This case addresses political speech, but says simply, and it's well known but worth reiterating at this stage in the argument, the court stresses there is little scope under Article 10.2 of the Convention for restrictions on political speech or on the debate of questions of public interest. And we say that will view very heavily with you when you come to consider whether there is any lawful way in which the Employment Tribunal could find for the appellant. She was clearly, very clearly, involved in political speech, as I've already mentioned. I've already mentioned to the parent, but the next point, perhaps it has not been mentioned so far, and it is this, that Article 10 protects the rights not only of speakers but hearers. It is relevant, we say, to the application of Article 10 to consider whether the information to be restricted might have been of significance to hearers. And we say that this was precisely such a case. There were many people at that time who were, or might have been, interested in this debate, and for whom the opportunity to be involved in a parliamentary petition might be very important.
Speaking for myself, I don't find the Vajnai, however should be pronounced, at all helpful. On the facts, the gentleman concerned is Vice President of the Workers' Party. At a demonstration, he wears a five-pointed red star. He's convicted of wearing a totalitarian object in public, that being an offence.
Yep.
And he says that infringes his freedom of speech. But if, for example, a teacher at the respondent school turned up wearing a five-point communist star or other political manifestation and was told school rules don't allow this, if you do it again you'll be sacked, that would raise completely different considerations.
I understand that the factual basis of Vajnai may be very different, and I say it is different, but that doesn't mean that the statement of principle is not an important one. And in addition, there are many, many enunciations of the same position in domestic case law. For example, Queen and Shiler and so on and so forth, which I wouldn't otherwise bring to attention, but it's a very, very well established and important principle.
I think we're all aware of that, but this is about, we're also all aware that they have to be carefully looked at, limits on permissible free
Sure.
speech, and the question is, where's the line drawn in any particular case?
That's true, but the relevance and weight of the objections, as it were, which lead to the placing of limits, depends on the weight of the speech which it is sought to infringe. It's simply that point. So, but having made that acknowledgement, as it were, I do very much want to underline the point about it not only being the appellant's Article 10 rights in this case that would issue, but those of her hearers.
Yeah, well, we've made that point. Yeah.
Another point that's important, and you'll find it set out in more detail in the submissions of the Association of Christian Teachers at page 117 of the supplementary bundle, is the importance in our times of the internet as a means by which people express views. In the early days of our membership of the ECHR, it was probably still the case that people still read and bought paper copies of newspapers. Nowadays they don't. They depend for the information which they receive on the internet, and that means that as Lady Justice Sharp said in Miller, protections that were previously applied to journalists now get applied to ordinary citizens. So, with that, I move, as it were, to the respondent's side of the balancing exercise, and of course it is a balancing exercise, but if we're applying Mrs. Justice Eady's approach, involving the application of Bank Malat and the well-known propositions of law which flow from it. But I want to now look at the respondent's side of the balance. It was said at the time that the appellant was guilty of illegal discrimination in posting as she did. However, we say that...
So can you just, it would help me to have an authoritative statement somewhere of what the respondent's case on justification, well, was, or I suppose is there a convenient place where officially we should be looking at the ET3, the grounds of resistance? An exercise I meant to do in advance of this hearing and didn't. It's just you're saying the respondents relied on this, respondents relied on that. I just want to see where they relied on them and the way in which they expressed themselves.
The discrimination point was one that was made at the time by Mrs. Dorry, the investigating officer, and indeed by the dismissing person, Mr. Conlon.
I just want to be sure that you're not, shying at Aunt Sally's. All sorts of bad points may have been made. This is a bad point. As the case went on, I just want to check what, as you understand it, and why the respondents are now relying on by way of justification.
Well,
we ought to be able to find in the skeleton argument, but and perhaps we can. But if you could show me the passage that you think sets out their case on that you're responding to.
Well, I have to say I've been very struggled with it myself, and the reason why I've struggled with it myself is that if you look at the respondent's skeleton argument, actually most of it's an argument about separability.
Well, I know.
So I find it very difficult to know the case I have to face on that, I have to say.
Well, perhaps, do you mind if I just ask, Mr. Jones, I'm not asking for submissions,
No.
but one way this case could go, if the claimant persuades us, is to say that the case doesn't need to be remitted because there was an interference of speech, the test is the justification test, and it couldn't possibly be justified. If that is an exercise we're prepared to do, it would help us to know where the justification on which the school relies, or will rely if it's remitted, is authoritatively set out.
Well, taking that in stages, firstly, of course, it's not in the submissions at first instance because separability was the defence that was being run by the respondent. It wasn't perceived to be a case about justifying. And it's only really once we get to the EAT and we get the remitted question that justification becomes
Yes,
the
I
issue.
see.
So at this point, the full justification defence is yet to be developed, and yet to be developed by someone other than me, I suspect, when this comes to remission. What we will say in the course of our submissions is we're going to take you to cases like Chinoveski and Illendal.
So I just didn't hear that bit.
We're going to be looking at some convention cases
Yes.
which talk about the boundary of protection in circumstances where the manner in which a particular exercise of free speech takes place allows an employer, or in other cases allows a state, to take action to restrict that speech, even though it falls short of the kind of speech that would engage Article 17 and thus not be protectable at all.
Well, as you say, you that's what you will be submitting later, but you may say for perfectly good historical reasons about the history of litigation, there isn't an authoritative statement of your case on justification. But by justification meaning the issue on which Mr. Justice Eadie has said it should be remitted. And I don't mean this in any way rudely, but I think I ought to, but having failed to get permission to cross appeal, it should have been apparent to you, shouldn't it, that from Mr. Adair's skeleton argument, that the claimant was going to be arguing that there is obviously no justification, so there's no need to send it back. In which case, this comes out more critical than I mean to be, it would have been helpful to have a statement of what the justification case would be. You may say, I shouldn't be put in this situation, but you have been by the litigation history, and we are where we are.
You're never going to hear me say that. The issue is a little different, though, in the purpose of today's hearing wouldn't be for us to justify the restriction. That, we say, is a matter ultimately for the tribunal. So the question...
Well, I know, but that means that you've won and said on the basis that it should be sent back. And you may well win on that. Yes. But it's an open question. Mr. O'Dare is seeking to persuade us, and you should not assume that he will not be successful.
I'm not.
That this is too obvious to need to be sent back.
Yes, so that's the question. What we don't think we don't need to to advance an argument that it is obvious that it is justified, merely that it is possible that it is justified.
Yeah, no, all right, but I agree with that.
Yes.
But you still got to say on what basis it is possible that it might be justified.
But let me be clear. It may be justified on the basis, one, of the matters which the school itself took into account, so that you'll have seen that what it was concerned about is the impact that it might have on parents, pupils and others. But taking it from a legal angle, the answer is because the convention cases make it clear.
Well, I see that. You're going, okay, but I just think I can't assume you're right about that second point, about what the convention cases show. And at this stage, my Lord Mayor, perhaps we'll discuss this over the adjournment. This case, the way I am thinking, and we will tell you definitively after the adjournment, is that we will want to have from you, with all the caveats you want about this isn't what the issue really should be, a summary statement at some point during this hearing and as soon as possible of what, if you lose on all your other points, you're going to be saying was the justification for dismissing, and indeed the other steps, but most importantly, dismissing Ms. Higgs for the post that she made.
Yes, well, I mean, I'm bound, as it were, by what was run at first instance, and the answer is that the posts were, in a form, including the way it was phrased and to some extent the content, that was so offensive that an employer would be justified in terminating it.
Yeah, I see. Well, I've flagged up this concern of mine, and I will discover to what extent it's shared by my lord and my lady. But you can start thinking about it, and we'll say something firmer about it at 2 o'clock.
Oh, your ET3, I've just looked at, is very short and simple. Even after the striking out of the unfair dismissal claim brought 1 week out of time, it is still saying it's a simple gross misconduct tip back.
Yes.
It doesn't really go into nuances.
It doesn't, but the tribunal's made findings about what the reason was. That has to be our reason. It also has to be our justification.
Well, it doesn't have to be your justification.
Well,
I-
I'll ponder it some more.
I agree. There ought to be some. There's normally some relationship between the two.
Yes.
Yep. Thank you.
Thank you.
I'm sorry. That's been helpful to me. And but Mr. Adair, you are to some extent, and again, not handing out either bouquets or brickbats, but you are to some extent in the dark what justification case you're meeting, and you're taking points out of the history of the case and saying, well, this can't be a good justification. That's really the exercise you're on, isn't it? Mrs.
Well, I'm saying what is there in the facts
Yes.
and findings which could possibly justify.
Whether or not they're actually going to be relied on as such. Okay, well, I think you can, these points are in your skeleton argument. I think you can run through them, but I think I wouldn't spend a lot of time on them until it's clear to what extent they're relied on. If necessary, you'll have a chance in reply or later in your submissions, because if you haven't sat down by 1 o'clock.
Yeah.
Okay,
Okay.
run through them anyway.
Right. Can I just say one thing in passing that may help you and your colleagues? It is that in the core bundle at 33 and following, there is the dismissal letter.
Yes.
And with reference to your point about that can have an impact upon the reason, you may wish, and I indeed wish to, show you paragraphs of
Yes,
that
well,
judgment.
that makes sense, obviously, yeah.
So
Just remind me where that is, sorry, in the supplementary bundle.
no, is the core bundle supplementary bundle 33. So,
Yes.
it may help you for me to look at that document with you, because
Yep.
it's likely relevant on any view, as it were, and just to point out certain paragraphs. So, on paragraph 30, page 35 of the supplementary bundle, sorry, 36, we have a setting out of part of the reason for the dismissal, and the topic considered from the middle of page onwards is reputation.
Yes.
And you'll note there that the panel agrees that there's no direct evidence of harm to reputation. The complainant was not criticising the school. And Miss Dorry, the investigating officer, confirmed that no other parents had complained. Sorry, my computer has gone AWOL. I'll just have to take myself to.
Before you go anywhere else, I mean, I don't interrupt what you're doing, but I had a question to ask you about page 36. So
Yeah. Let me just. So 36 there you have the discussion about reputation. No
yes,
doubt.
I mean the fact. What I was just going to ask you was, factually, the points that are made almost exactly in the middle of the page, starting with the sentence, however, are factually all correct. Is that right? For example, that some of the Facebook friends are members of the staff at the school, others are parents of pupils,
Yeah.
and that although she used her maiden name, her friends would know who she was effectively. That's all undisputed.
Yeah, all this is.
And also, I'm pretty sure this is right, but there's a risk that elderly judges like myself can be wrong about this. But even if you restrict your privacy settings to your Facebook friends, you are at the mercy of your Facebook friends reposting them in circumstances which show your identity. Isn't that what's being said here?
I think that's right. Yeah.
Yeah, I thought that was right in doing some checking with people who use Facebook more than I do. But that's what I thought to be the case, and it is not disputed. Thank you.
Although one might note, in the light of the point I've made about the scope of Article 10 and other people's rights, that's not necessarily negative.
No, I dare say, but I just wanted to know it's factually correct.
At the bottom, by the bottom, 2/3 of the way down, paragraph beginning, we have therefore concluded. We've therefore concluded that whilst there was no actual evidence of reputation
Yes.
harm, there was the potential to be. We also agree unlikely that anyone reading these posts would consider they represented the school's views.
Yeah.
I mean, in my submission, that is absolutely astounding that the school recognised that and still dismissed. Over the page.
Well, let's just bottom that out. I'm not saying anything about the claimant's views expressed in this case, but suppose you had someone on your staff who had outrageous racist views and had expressed them semi-privately in this way. Would it be legitimate to say, and these were only views, they were of no, they hadn't affected their conduct in any way at school. Would it be legitimate for the school to say, if it becomes known that we've knowingly employed someone who has these views, even though they are clearly not the views of the school, it will be reputationally damaging for us? What's
the key difference about that case is this: that someone who was expressing racist views, depending exactly on what was said, would be putting themselves outside Article 17 in the first place. Because, so there would be no, and this is why...
No, that's a fair point. That's a fair point. I'm trying to think, I suppose what I'm getting at, I'm just concerned with whether there are any circumstances in which it is legitimate for an institution to dismiss someone who holds views which, though not barred by Article 17 or by whatever the phrase is in the domestic legislation that was interpreted in Nicholson and Granger, nevertheless would make most people of the kind with whom the school had to deal reluctant to deal with it. And we get perhaps into the third party.
We do. That's where that goes.
Area.
That's where that goes.
Yeah.
So I don't want to anticipate too much my argument on that front.
Yeah.
That's exactly where that goes.
So really, reputational risk based simply on employing someone who has very unpopular views will never, on your submission, be a legitimate consideration.
Almost never. And you see, my Lord pointed out quite rightly what might have been said in this case. If it follows that nobody would have thought the views were the views of the school, what would be the point of dismissing them? And the only point of dismissing them would be that either the school or somebody else, probably somebody else, didn't want there to be employed a person with these views. The views aren't going to be...
Yeah.
Yeah. That's a very telling admission in my submission. Can we turn over the page to paragraph 37? And I'd just like you to glance through paragraphs 3 and 4 on that page.
Just the terms of the two allegations.
It's the paragraphs we also consider, and we heard that.
Oh, sorry, I misunderstood. Yeah, okay. I was looking at the wrong paragraphs. Give me a moment. Yes.
That is the evidential basis for the submission I made earlier, that the intervener and the complainant and the school drew from the claimant's beliefs an assumption that she would be a danger to LGBT kids, even though they knew all about her conduct, and that conduct gave them no basis to think like that.
Hadn't before noticed, I don't think anyone's, the short paragraph after those two, your online persona was not consistent with the professional image. Do you have any submissions about that?
Well, simply that was a summary of what had gone before. There was no evidence at all of any other problem with the claimant's online persona. Just same point in different words.
Yeah.
My next point on reputation is this. The tribunal acknowledged in its reasons the possibility that the school might have dealt with the issue by essentially making a joint statement with the appellant to the effect that she was not opposed, however much people might feel the contrary, to those who are LGBT. And in doing that, the tribunal, which didn't follow through on that analysis, was raising a very important point about reputational arguments. And the point is this, that they are inherently weak, because in most cases, the employer will be able to disassociate themselves from the views which have been found to be objectionable. And this was such a case. There were other reasons of meeting reputational concerns apart from dismissing the claimant.
Can I just flag up, and you may want to deal with it now, or you may want to deal with it later. That's true about dismissal. Say it's true about dismissal. But there are, in fact, 4 detriments relied on here.
Yep.
Suspension, disciplinary procedures, dismissal, and appeal. Would your submission be the same if all the school had done was suspended the claimant?
I would, of course, acknowledge that, as is standard, suspension is a precautionary measure, etc., while investigation is done. So, I think I want to give a final view later, but
yes, but I'm flagging it up because one thing we'll have to think about is, suppose, and only suppose, that we were persuaded that there was no need to remit on the question of dismissal, because dismissal is a very serious sanction, but that it would have been justified, or might arguably, because that's all Mr. Jones has to show, have been justified to investigate and to suspend pending investigation. There might, in theory, be a slightly awkward situation where we remitted part of the case and not the rest. The real meat of this case, of course, is in dismissal, isn't it?
Dismissal and appeal.
There's a habit, which I suppose I can't say is wrong, but it's made cases overcomplicated. In any case where people are complaining of disciplinary proceedings, for them to play in a separate detriments of being suspended, investigated, then of the procedure being initiated, then of the result, then of the... It does overcomplicate the analysis.
Well, it does and it doesn't, in that pragmatically it definitely does, but juristically I don't think it does.
I see juristically, I see. I mean, you could have a case where someone hadn't been dismissed but still been traumatised by being investigated.
Well, absolutely so. And in this case, given that...
But the answer might not be the same.
Oh, it might be. Might not be. No.
Okay, well, I just wanted to flag that up. It's quite useful sometimes to do this because you may want to think about it further, and the other parties might want to think about it further. But do continue with where you were.
I am continuing with things that I speculate might be on the respondent's side of the balance, the balance in the absence of prior information. There is one point, however, that I think I do want to emphasise, notwithstanding those difficulties, and it's this. It's telling, in my submission, that while the school said it would have tolerated the claimant's beliefs if they'd been set out as they were set out in the pleadings in a very sanitised manner. That's what part of what the school's case was. It was the manner, not the actual content of the beliefs. It is, I say, telling that the school put forward absolutely no evidence at all that it had in fact encouraged debate about these issues, as one might expect, given that it was before Parliament, on the part of parents. I say that fact, although it's a negative inference from the negative, it does weigh in the balance. And I refer there to a very important dicta of Lord Justice Sedley in my submissions. And I'll bring a reference there after lunch.
Is that Reverend Beck?
No, it's Anya.
Oh.
Lord Justice Sedley basically says it's not enough to say we would have treated anybody else like this. You've got to go and show you actually did. And we say an analogous principle applies here. They needed to show, to make their case strong on remission and before you, that they actually were encouraging debate about these matters. That would have undermined, if it had been true, my point about the wider Article 10 rights of the community. Can I take you now, and I've taken to it before, but I think it's important that we have it in front of us, to the core bundle, page 193. Excuse me a moment. It's actually 94 and following. This is the judgment of Employment Tribunal, and I want to take you to paragraphs 60 and 63. Now, it's our submission that the task facing the respondent is to show that dismissing Mrs. Higgs was justified because reasonable people might think that her posts showed that she was homophobic and transphobic. That, and probably only that, is the reason on which they rely. It's fair to say that the last 3 lines of paragraph 61 successfully add to that, or need to be considered. So, was it justified for the respondent to dismiss by reason of the fact that reasonable people might think she was homophobic or transphobic? That's got to play at least a part of it. And the initial question that I have is this: why does what hypothetical reasonable people might think possibly afford the respondent a justification for dismissing someone who has been engaged with political speech? And the more one thinks about it, the conclusion I would suggest is this, that it doesn't. I mean, just hypothetical reasonable people somewhere might think that. How does that provide the weighty, pressing need for dismissal? The answer might be this. In the last 4 lines of paragraph 61. That behaviour, the school felt, had the potential for a negative impact in relation to various groups of people, namely pupils, parents, staff, and the wider community. It was a suspicion that she had done so that brought about the entire process. So it could be argued that the base reason is amplified by those last 3 lines, which of course brings us straight away to a possible negative impact in relation to various groups of people, namely pupils, staff, and the wider community. It's fair to say that the Employment Tribunal doesn't explain at all what that impact might be. It's just one is almost forced to speculate. And of course that is not a problem for the appellant, but it's a big problem for the respondent, who is, as a result of Justice Eadie's order, confined to the reasons and surrounding facts as already given. And our base point for criticising, dealing with the end of paragraph 61 is this, that it is simply unspecific, speculative, and lacking in detail to form the basis of a justification argument. One might say that had they approached the matter properly when pleading the ET3, we would know with much greater detail what this meant. But we didn't, and we don't, and that is not the appellant's problem. I want to deal, though, having made that submission that it's just far too vague and speculative, with the idea, the various constituencies referred to within that sentence. Let's deal first with negative influence for pupils. In my submission, that is simply adopting by the Employment Tribunal of the school's stereotypical assumption in the letter of dismissal that the appellant would harm LGBT individuals. There is no suggestion anywhere else in the whole material, as far as I can recall, to suggest that any other form of harm or negative impact to children was in mind. So if I'm right in the implication that the position taken with regard to her work with children was stereotyping, that made it discrimination, and that made that taints and therefore causes to fall the whole of the justification argument. You can't have any part of a justification argument which is itself discriminatory. The next section, that group of people that's referred to, is parents. Negative impact in relation to parents. We have no specifics, but the only plausible way of understanding that is to think that a lot of parents thought like the actual parent, the one parent. But firstly, that is highly speculative. Parents might just as easily have wanted to know all about these various issues as they applied to their children. So that is wholly speculative, and then we move to the staff. We simply have no idea what is meant by that. Presumably what is meant by that is some of the staff might object to Mrs. Higgs' views. Well, that is hardly a justification argument, in fact, it's a admission of liability. And it's worth my while pointing it out to you now, and I'll bring you the reference after lunch because it's temporarily escaped me. The decision of the ECHR in Sahin and Turkey, 2005, which states that in a pluralistic society, the first job of a public authority, or in this case an employer, is to teach disagreeing groups to tolerate each other, to promote toleration. And in my submission, for that reason, but also for many others, as I've set them out, there could hardly be a reason, even if it was specified, in the views of parents and staff, which justified discrimination. My Lord, that would be a convenient moment for me to adjourn for lunch, although it's obviously a matter for you.
Very well. We will come back at 5 to 2.
Court rise available.
Sorry.